Well, welcome everyone. We have about 200 registered to attend today, which is fantastic, especially on a Friday afternoon. This is one of a series of webinars in our recently released report, Respect at Work, into the National Inquiry into Sexual Harassment in Australian Workplaces. Each webinar we're holding is focused on a different stakeholder group, and I'm really glad to be here today with Michele O'Neill to talk about the topics that are most of interest, I think, to the unions and to workers in particular. I'd like to acknowledge the traditional lands of our First Nations people. I'm presenting from the lands of the Wurundjeri and Boonwurrung people of the Kulin Nation, and I ask you to take a moment to pay your respects to the traditional owners in your lands. Please be aware that this session is being recorded and will be available to share with others in the next week. And I'm also mindful that people listening to this webinar may find the content distressing. So please remember that there are support services available in addition to your unions. Should you need them, you can call 1800-RESPECT or please call 000 if you're in immediate danger. So thank you for the questions you've posed ahead of time, and you can also send through questions at any time using the Q&A function located either at the right of your screen or at the bottom. It looks like a text message symbol. The Q&A is pre-moderated, so there may be a short delay before your questions appear publicly. Michele and I will answer those questions, or as many of them as we can, in conversation after we've each made some opening remarks. And also participants can also turn on live captioning if you require via your settings, which are indicated by 3 dots at either the right or the bottom of your screen. Now to introductions. So many of you will know that I am the Australian Sex Discrimination Commissioner, and my job is to promote gender equality and fight to remove discrimination and harassment. I started the role in 2016, and since that time have worked on a number of significant Australian Human Rights Commission projects, including with universities, defence and Play by the Rules. I'm delighted that Michele O'Neill has agreed to join me as a presenter today. As you all well know, Michele is the president of the Australian Council of Trade Unions and was also a member of our invaluable Respect at Work reference group. And I'm very grateful for her contribution to our inquiry and again today. So Michele, can I get you to introduce yourself a bit more personally to our audience?
Thanks, Kate, and hi everybody. And I also want to acknowledge the land that we're all on, that I'm today in the land of the Wurundjeri people of the Kulin Nation, and pay all my respects to their elders past and present. And it always was and always will be Aboriginal land. And yes, thanks very much for the opportunity to have this webinar today, Kate. We've all got used to a different way of working, and I wanted to really begin by just saying a huge thank you and acknowledgement to you for the leadership you showed in conducting the inquiry into sexual harassment in Australian workplaces, and the work that you and your team did in pulling together what is a very impressive report, Respect at Work. And I know that many of the people who'll be on the webinar today, even though I can't see you all, were very active in ensuring that the voice of working women was heard and working people was heard during your inquiry. And we appreciated the fact that you recognised the really important role that unions play in making sure that we have safe workplaces, and that the issues like sexual harassment are at the forefront of change that's needed across our entire labour market and in workplaces and at home. And the last thing I'd say just in introduction is that thanks everyone for making the time. I know how demanding work has been and the amount of juggling that so many people are doing, trying to make sure that we stay safe and do what we're required to do in our work lives and in our home lives. So appreciate you all for coming into the webinar, and back to you, Kate.
Thank you, Michele. And I'll reiterate that thanks. I agree that these are very strange times. So just starting, I guess, is a quick refresher about the definition of sexual harassment under the Sex Discrimination Act. At its simplest, sexual harassment is unwelcome conduct of a sexual nature, which reasonably causes the person harassed to be offended, humiliated, or intimidated. And the National Inquiry specifically focused on sexual harassment at work. So we commenced the National Inquiry in 2018 with the support of government, unions and employers uniquely, and off the back of the global Me Too movement, which placed a renewed spotlight on the prevalence of sexual harassment at work, although I know many participants have been well aware of that prevalence for a long time. The goal of the inquiry was to examine the nature, prevalence and drivers of sexual harassment in Australian workplaces and measures to address and prevent it. Our Respect at Work report is the culmination of 18 months of work involving a survey of 10,000 workers, 60,000 public consultations with 600 participants, 460 written submissions, global research and economic modelling. During the inquiry, we ran targeted consultations with workers and unions, and many unions and representative groups also made submissions to the inquiry. And I want to thank the participants online today who did also contribute to the inquiry. Your helpful input is one of the reasons I was determined to reach out to the union audience, specifically during this webinar series, to continue the conversation about sexual harassment, which we started last year. I launched Respect at Work alongside Minister for Women, the Honourable Senator Marise Payne, on Friday the 6th of March 2020. And Minister Payne and the Attorney General Christian Porter welcomed the report and said the Australian Government would carefully consider its recommendations. They also underlined the Government's commitment to ensuring Australian workplaces are safe and free from sexual harassment. So to the findings. Many participants in the inquiry, including many supported by union representatives, shared with me their devastating experiences of sexual harassment at work and inadequate responses. Most heartbreaking to me was the long-term harm and the financial hardship that I heard that was caused to many by the experience. We found that sexual harassment is a common experience. Our survey and inquiry told us that workplace sexual harassment is pervasive. It occurs in every industry, in every location and at every level in Australian workplaces. In 2018, 1 in 3 Australian workers had experienced workplace sexual harassment in the last 5 years, up from 1 in 5 workers in 2012. We found the current system places the onus on the victims to complain. And yet we found that only 17% of people who said they were sexually harassed at work made a complaint, which is consistent over a number of our surveys. We found that sexual harassment happens in all workplaces. In our survey, we've collected industry-specific data for the first time across 21 ABS-defined industry sectors, which provides a valuable resource for industry action. And we found sexual harassment has a high cost. Deloitte Access Economics modelled the economic cost of workplace sexual harassment for the inquiry. They estimated that workplace sexual harassment cost the Australian economy $3.8 billion in 2018. Clearly, we have a sexual harassment problem in Australia. The inquiry showed us that the current system for addressing workplace sexual harassment is complex and confusing for victims and employers. Our inquiry revealed the urgent need to shift from the current reactive complaints-based approach to one that requires positive action from employers and has a focus on prevention. Our Respect at Work report proposes a new approach which builds upon Australia's existing policies and initiatives through 55 recommendations which fall under 5 areas of focus. Firstly, data and research to deliver useful industry-based information about the nature of sexual harassment and effective responses. Secondly, primary prevention of sexual harassment through education, media and community-wide initiatives. Thirdly, a refocused legal and regulatory framework which recognises the mutually reinforcing roles of discrimination, workplace and safety laws. Fourth, better workplace prevention and responses, which are leader-driven, practical and adaptable. And finally, better support, advice and advocacy for people who experience sexual harassment. For today's webinar, I'll focus on the workplace prevention and response, the legal and regulatory framework and the support, advice and advocacy recommendations in the report. So during the inquiry, there was widespread acknowledgement by employers, workers and unions that the current approach to preventing workplace sexual harassment was not working. We heard that employer methods had remained largely unchanged for decades and were failing to prevent or effectively respond to workplace sexual harassment. It became clear through the inquiry that employers, and particularly small business owners, wanted greater guidance on what good practice looks like for addressing workplace sexual harassment. In response, the Commission recommended a new framework for workplaces to better prevent and respond to sexual harassment. The new framework provides a more holistic approach that looks beyond policies, training and complaint handling procedures. It's adaptable for businesses of all sizes and in all industries. The new framework has 7 areas of focus, 4 to prevent sexual harassment and 3 to respond to sexual harassment. To better prevent, we need, firstly, strong leadership to create a safe workplace environment. Secondly, a greater focus on risk assessment, drawing on a commitment to transparency, a willingness to learn from past experience, and a philosophy of continuous improvement within the workplace. Thirdly, policies which build an organisation culture of trust and respect. And lastly, we need to use workplace education and training to improve knowledge and develop a collective understanding of expected workplace behaviours and processes. But what happens when sexual harassment does occur? The framework recommends 3 areas in which employers can focus their response efforts. Firstly, providing support to workers through the reporting process and prioritising worker wellbeing. Secondly, increasing reporting options for workers and addressing barriers to reporting. It will be particularly important to create new ways for sexual harassment to be addressed other than launching a formal investigation, which is a route down which very few victims go. And lastly, measuring, which means collecting data at a workplace level and an industry level so that we can understand the prevalence, nature and impacts of workplace sexual harassment and evaluate the effectiveness of initiatives designed to address it. And as I mentioned that, I'll make a call out to the work that the SDA did in conducting a survey of their industry members. To embed this new framework, excuse me, within Australia, we made several industry-specific recommendations, including that industries develop industry-specific prevalence surveys like that one conducted by the SDA, codes of practice or awareness-raising campaigns. We recommended that unions be involved in the collaborative process to set up these industry initiatives. Of course, employers and workers will need guidance as they work to implement these recommendations. And that's why we also recommended that unions, employers and employer associations work together to develop an online platform called Respect at Work, which will be a one-stop shop for information, education and resources on workplace sexual harassment. Moving to the legal framework. As many of you will be aware, the 3 main legislative schemes that regulate sexual harassment in the workplace are the anti-discrimination laws, the Fair Work system and work health and safety laws. Our inquiry concluded that the interaction between these 3 schemes is confusing and sometimes inconsistent for workers and employers. However, we found that there are significant benefits to each of these regimes, which are well recognised across Australia. So our recommendations are designed to strengthen and clarify these frameworks so that they can work in a complementary and mutually reinforcing manner. We found that the Sex Discrimination Act, or SDA, should continue to be the primary piece of legislation regulating sexual harassment at work and the anchor for consistency across the state and territory Equal Opportunity Acts and the Fair Work Act and safety regimes. We identified a range of enhancements required to make the SDA and the Australian Human Rights Commission Act better suited to contemporary experiences of work. These enhancements include clarifying that the SDA covers all people in the world of work, including those who are paid, unpaid and self-employed, and also state public servants. Expressly prohibiting sex-based harassment and prohibiting creating an intimidating, hostile, humiliating or offensive environment on the basis of sex. Extending the Commission's discretion to decline complaints from 6 months to 24 months after the alleged unlawful discrimination took place, and extending liability to those who aid or permit another person to sexually harass a person. Based on recommendations in union and legal centre submissions to the inquiries, we also recommended that the Australian Human Rights Commission Act be amended to allow unions and other representative groups to bring representative claims to court. This would increase consistency with existing provisions in the Act, which allow unions and other representative groups to bring a representative complaint to the Commission. We've also recommended that a positive duty be introduced into the SDA. The positive duty requires all employers to take reasonable and proportionate measures to eliminate sex discrimination, sexual harassment and victimisation as far as possible, and would be accompanied by functions for the Commission to assess compliance with the duty and enforcement. We observed during the inquiry that many large employers assumed that such a positive duty already exists, as it does in Victoria. The Workplace Prevention and Response Framework, which I mentioned earlier, will be key to facilitating compliance with this duty. And to improve our national approach to discrimination laws, we also made a recommendation for state and territory governments to amend their anti-discrimination legislation with the objective of achieving consistency to at least the minimum standard of the SDA. Now, we heard that fair work is regarded as the central place for workplace grievances and a system that has a long and respected history in this country. While the Fair Work Act covers grounds of discrimination, currently it does not expressly prohibit sexual harassment. Unions and workers with multiple workplace grievances told us they wanted a simpler system to raise workplace concerns in one place. Employers told us that they got mixed signals from the Fair Work Commission when it came to sexual harassment misconduct, especially through the unfair dismissal jurisdiction. One key recommendation resulting from the inquiry was to expressly prohibit sexual harassment under the Fair Work Act, using the definition in the SDA. Many submissions from unions, legal organisations and NGOs argued strongly that expressly prohibiting sexual harassment in the Fair Work Act would strengthen the way the Fair Work system handled sexual harassment matters. Other key changes we recommended to the Fair Work system included introducing a Stop Sexual Harassment order equivalent to the Stop Bullying order currently in the Act, clarifying that sexual harassment can be conduct amounting to a valid reason for dismissal in determining whether a dismissal was harsh, unjust or unreasonable, and including sexual harassment in the definition of serious misconduct in the Fair Work regulations. Australian work health and safety laws already impose a duty on employers to prevent sexual harassment in the context of the broad duty to eliminate or manage hazards or risks to workers' health, which includes psychological health and therefore sexual harassment. We heard through the inquiry that there's an urgent need to raise awareness that sexual harassment is a work health and safety issue. We therefore recommended changes to the model work health safety regulation to deal with psychological health and the development of guidelines on sexual harassment, which could be used to inform the development of a code of practice on sexual harassment. During the inquiry, we heard that the support, advice and advocacy services available to victims could be under-resourced and confusing. Respect at Work recognised the valuable information, resources and referral services provided to victims by unions and other groups such as community legal centres, and we recommended further investment in these existing services. We also recommended that a workplace sexual harassment council be established and funded to improve coordination, consistency and clarity across prevention and response activities. Council membership would include union representatives alongside delegates from the Fair Work Commission, Safe Work Australia, Workers' Compensation Authorities, Human Rights Authorities and employer associations. One of the Council's key tasks will be to coordinate the development of guidelines to support standardisation across information and referral services for victims. We also heard repeatedly of the importance of timely access to specialist counselling for victims of sexual harassment. Given the prominence and existing expertise of 1800 Respect hotline, the Commission recommended that it be funded and expanded to support sexual harassment victims. The Commission found that support, advice and advocacy should be delivered in a holistic way, providing it as seamless an experience as possible for victims and other people affected by workplace sexual harassment. This could involve smooth and speedy referrals between services or access to an all-inclusive support, advice and advocacy service. We identified that working women's centres already provided such a service in some jurisdictions, and unions can also provide holistic support to workers. Our last recommendation was the adequate resourcing of legal aid commissions and community legal centres to provide quality legal advice and advocacy to victims of sexual harassment. So our world has changed dramatically since our report was tabled in Parliament on 5th of March. The need to address sexual harassment has not lessened. However, the immediate priority for our governments and many workplaces has changed, and rightly so. And while the government's response to Respect at Work may now be delayed, I think you'll agree that unions and employers already have, in our comprehensive report, the information they need to take action to create more productive, respectful and safe workplaces. So Michele, I now look forward to hearing your reflections on the report, and I also encourage participants to continue to send questions through for Michele and I to answer after her address. So over to you, Michele.
Thanks very much, Kate, and thanks for taking us through in such a comprehensive way the report today. I can hear a bit of an echo on my, okay, all right. So hopefully it'll just me that can hear it, and the rest of you I sound fine too. So yeah, hi again, everybody. I did want to, as I said, thank Kate for that and taking us through that. It's such a comprehensive report and deals with so many issues that are important in terms of trying to bring about fundamental change. And we're going to pick up a bit later where Kate ended about what's been the dramatic impact on COVID-19 to women, which is so disproportionate in every way. But I thought I'd start with, before we deal with that issue, talking about the report itself and some of the key recommendations that are very close to what the union movement has been talking about for a long time. We do appreciate that we had the opportunity to put them to you and that you did consider them in the way you did. So I'm not going to go through all the recommendations because that's really not the point. I just want to touch on ones that we think are really critical to bringing about fundamental change, which is not to diminish the others, but just to try and have a bit of a focus for this afternoon's discussion. The other thing I'd say is that, you know, it is, of course, it was unpredictable that so closely following the release of the report, Kate, that we would end up in a pandemic, but we are concerned that that shouldn't be a reason for the government to not act. So we know that they accepted your report and welcomed it, but we are concerned that we are now in June and we're yet to hear from the government a comprehensive response. And of course, what we want to see is them adopting the recommendations and acting. And if anything, what's happened during the pandemic has made that more urgent, not less. So we do want to see that there's a change that comes about and comes about quickly. The issues, I'll start with talking about the recommendations that go to the government itself implementing recommendations, because I think that as always with a report like this, such a massive amount of work goes into it. So, and as you saw from our own survey and your surveys and then from the submissions, this is something that is really deeply felt. And it's deeply felt because it has such a dramatic impact on people's lives and is so devastating in terms of its impact on every element of our life if you're experiencing sexual harassment. And the need for not just for the government to accept the recommendations, but in fact for them to fund it, because we know change doesn't happen by just saying, well, thanks very much for that great report, we agree with you. Many of your recommendations require significant government resources to come to life. So we're committed to being part of the ongoing campaign to ensure that the government does respond and that they do put adequate resources into implementing your recommendations. And they've got to lead. You know, you can't sort of ask for a report like this and then say, oh, well, that's great. They've got to step up and show leadership in terms of the changes that you recommend. We were very pleased to see the changes that you addressed in the Fair Work Act. And we, as you know, for workers and for unions, part of the difficulty with the history of what's happened in other jurisdictions outside of the Fair Work Act is that they've often been harder for workers to access. They're not as familiar with them. It's a longer process, often a process that hasn't been able, because of the limitations, to be able to quickly give people a response and make sure they're safe. And what we know in workplaces is that one of the terrible consequences of harassment is that it's often the person who's being harassed who bears the brunt of the behaviour in every way in terms of it getting resolved or not resolved, rather than the perpetrators and those that are ultimately responsible for the fact that the workplace hasn't been safe. So really embedding the idea that this is a workplace issue, like that it's a workplace right, that you've got a right to be safe in every way at work, and that harassment and sexual harassment is a significant risk to every worker, is something that we think your recommendation to include the provisions in the Fair Work Act is going to go a long way to addressing that. And also that we would use the same definition as the Sex Discrimination Act. So having the Fair Work system itself clarify that is very important. And we also support the idea that there will be the capacity to have orders to stop sexual harassment. So a worker knowing that they can go to the Fair Work Commission with their union or themselves, go there and actually seek an order to stop harassment is such an important thing. We know that you've recommended that, excuse me, model be based on the current provisions of the stopping bullying orders. We've got some concerns about those and the operation of those, so we do want to make sure that in any drafting or consideration of that we don't see the same mistakes made, that there's a clearer and tighter provision for stopping sexual harassment orders than currently apply. The other thing that we're very supportive of is the need to make sure that work health and safety legislation also covers what is needed as far as preventing sexual harassment and stopping sexual harassment in the workplace. We support that you have proposed that there be a regulation on psychological health. We actually think it's better to describe that as psychosocial health, so it's a broader concept. and that it does deal with all of the elements beyond just the psychological, but the psychosocial elements as well. And you would know that this is a recommendation that came out of the Boland Review too. So we think the fact that you've recommended it as well as out of the Boland Review, that there is really nowhere for the state and federal regulators in this area to go to not do this. It could be done now. There's nothing that is should delay this, and we want to make sure that there is a immediate action taken to develop up the regulation and a code. Again, you would see that it's something that is we want to see more than guidance. We think that time's well past for people just to receive guidance about this. We think there needs to be a code established around it. The fact that this should also have training in place is, of course, critical, because you can't create a new regulation or code and then not make sure that that's fully understood by workers in the first instance. They need to know what's available for them and what their rights are, but also, of course, employers have to understand their obligations. So you are right, that critical element of not just getting the code in place, but making sure that there is a training and education element to it is very important. The first, just back on the sort of implementation of this one, we think the very first step would be for the Commonwealth Government to accept it, but also then to ask Safe Work Australia to start a process of drafting a model work health and safety regulation, and to do that in consultation with unions and employers. And we think that process is something that should be happening today. There is no reason for that not to take place. That then means that, you know, the states are involved in terms of considering that through Safe Work Australia, and we could have the Attorney General have that process begin, as I've said today. The issues around workers' comp are really important too, and your recommendations there. Again, having the workers' comp bodies to undertake training and education on this. We know that so many times women in particular have experienced sexual harassment that has dramatically impacted on their ability to continue work in many cases, meaning that they haven't been able to work, that they've been very have suffered consequences in terms of their health in every way, and have been not always, this hasn't been well understood or accepted within the workers' compensation system. We want to make sure that that training is really gender responsive, that it deals with gender inequality as well as gender-based violence, and that it really does dig down to the causes of this rather than just dealing with the effect, and will play a really important role. We don't think training is enough, though, that there does need to be further reform in terms of workers' compensation law along the line of what we've put to you in our submissions. And now, getting to your Act, the Sex Discrimination Act, we do really support the changes that you've proposed. The fact that the objects should have that broad change about achieving substantive equality between women and men, that we want to see sexual harassment as expressly being prohibited, and the creating or facilitating an intimidating, hostile, humiliating or offensive environment on the basis of sex is also prohibited. They're very strong and important recommendations, and the coverage of everybody in the world of work rather than a narrow notion of an employer, which has left so many workers, increasingly leads so many workers out of the system. And also making sure that state public servants are included in there as well. The idea of having a positive duty, so the active requirement of a positive duty on all employers to take action that's reasonable and proportionate, again, is a strong recommendation. They have to have responsibility and see that they have active responsibility to eliminate discrimination, sex discrimination, sexual harassment and victimisation. And the idea that again not only needs to be in the Act, but that obligation needs to then be fully understood by employers. We need to make sure that these changes are given life in terms of changed behaviour, and they won't be given life unless you have the adequate resources to not just make sure the Act is changed, but that people understand their obligations. Having the function to assess compliance and with that positive duty is critical to that. You can't have new duty and then have nobody enforce it. So we want to see the enforcement measures put in place and well resourced, and the capacity for you to be able to inquire if the recommendations accepted into systematic unlawful discrimination, including systematic sexual harassment, is again a critical recommendation, because we know that many of the things that you discovered in the inquiry and that we face every day in workplaces around the country are that it's not isolated one-off incidences. This is a systematic problem of power imbalance, a problem where women fundamentally are not treated equally in the society as a whole, but in the world of work as well. And we all know that. We know the figures of how on a daily basis, because of the work women do, the feminised industries, the insecurity of the work that we're in, all of this exacerbates, and low wages exacerbates the likelihood of them being in workplaces where systematic abuse can occur and discrimination can occur. So having you have a role that's not dependent on a brave individual making a complaint, we think will change the lives of thousands of women, and we really want to see that implemented. And of course our capacity as unions to be able to take complaints is a really important part of that too. We so often represent women who are courageous in a million ways, but the notion that they alone should have to sort of bear the brunt of trying to rid their workplace, not only protect and keep themselves safe, but rid the workplace of harassment is unacceptable. You know, the very point of unions is that we can exercise collective power and influence, and so our right to be able to do that on behalf of workers and our members is a very important thing. So I probably will stop there, but to say that I've picked out a few things that is not to suggest the rest of your report is not important, but I wanted to focus in on areas of change that we are up for being part of a campaign with others about, and you would know that we've worked not just across the union movement in a united way around this inquiry and your report, but we've also had strong allies with others in the community and non-government sector and some elements of business as well who agree with us about this. So we're committed to continuing this campaign. What I haven't mentioned but will end with, of course, is the need to have the ILO Convention ratified and implemented by this government. We are concerned again about the delay and very disappointed that one of the major employer organisations has opposed that. So we think we're part of a global movement. We understand that this is not just an Australian problem, but Australia should play its part in recognising the significance of the ILO adopting that convention and make sure that we breathe life into it here in Australia. So that fight is one that we're part of here and we'll keep being part of globally too. Kate, I might, as I said, I know that you want to take us to a bit more to the COVID-19 thing, so I'll hand back to you and make sure that we can come back to that. But I just want to end by saying this. Unions know that this change is one that it's not the first time there's been a report, it's not the first time there's been an inquiry, and we are more determined than ever to make sure that the work that thousands and thousands of working people and their unions and yourself and others put into this report doesn't gather dust. There's no time to waste here. Lives are literally at risk every day, and the dramatic and terrible impact of sexual harassment on workers, particularly women, is something that we are not prepared to let continue. So we're as determined as we could be to make sure that these changes happen, and thanks again for all your hard work.
As happens at least once on every meeting I have, somebody is on mute. Thank you very much, Michele. Those were fantastic words, and those wrap-up words were particularly heartening for me, but also I do, in the opening remarks, I didn't tell the stories, but the stories particularly of workers and then of people that were brought to us with the support of unions and with their sort of always their voices with union kind of support behind them, are probably the most memorable of the experiences that I heard that gave me the same drive and motivation as you. The harm, the long-term harm, the complete damage that can be done by this, in contrast to, I think, what people have traditionally assumed was not a big deal. That story is pretty stark. We will go to, we've got some questions, and I've of course got, because there was so much in the inquiry and so much in the content that Michele's talked about that we can go to, but I just thought while I've got the screen, I would just, not to intimidate you, but to say thank you to anyone who's read the full report, but also just remind you, and if it's not put in the chat, you will have received it probably in an email, that we do have a very nice community guide that gives an overview of the whole picture. And the reality is the report is structured in a way where you can dive into the bits that you want to know about. My other two, because I'm home, I've got all these things that I can show you. My other two, favourite is the survey report. And then I think if Julia Fox is listening, that's our beautiful SDA report into the retail and hospitality sector. So that was really helpful. I will talk to COVID. One thing that I will do, just in anticipation of people raising this with us, is that we identified through the inquiry that sexual harassment was caused by significant power disparities, as Michele has described. And in particular, we particularly looked at and identified that systemic nature of the issue about who was at higher risk, what industries had higher risk, and what systemic factors were there, and what environments or situations were at higher risk. And in particular, just while we do talk about women, and certainly women are in the majority, our research shows us that 39% of women have experienced sexual harassment in the last 5 years, but also 26% of men. And men who spoke to us about their experience absolutely reported that they were even, had even more difficulty speaking up. And it was often more, for both groups, much more likely to be harassed by other men, but it's certainly an issue that affects so many workers. The other high rate of harassment, the highest, was of young people. So people in the ages of 18 to 29 years of age were at highest risk. But even workers from 15 to 17 years of age were experiencing, in the last 5 years, which must be less because they weren't in the workforce that long, where 1 in 5 workers had experienced sexual harassment. So we know, and I know particularly the union movement is very conscious of the nature of the work, but also the vulnerability of some of those people. So what I thought we would do to start our conversation, partly because you and I are both here, is to really talk about, since the 5th of March, what we've both sort of immediately and with huge speed turned our attention to. So in looking at the report, we know that the report is in the Attorney General's Department. It is being considered, and it is with the government to respond, and we expect a response in due course. But in the meantime, I'm obviously, in addition to doing these conversations, very much focused on the impact of COVID. That really has amplified the gendered issues that impact women in work particularly. And so the things that just as well as I, the gendered segregated nature of our industries, the that sort of more likely to be part-time, underemployed, casual employment of women, and also self-employed, and the impact that's had, and also the higher rates of responsibility for unpaid caring and domestic roles. And as an intersection, women are either or are both on the front line and also at the most risk in terms of their employment in whatever industry. So my focus has then turned to what can be done. I'm interested, Michele, because when I turn on my television, I can see you're busy. How in particular, how has your life changed, or how has your work changed shape, and what's kind of your, just any reflections you can give on the path forward, not just for women but for workers in this COVID situation?
Thanks, Kate. Well, it's hard to conceive that really it's only been a few months. It seems to have both been a very, very long time, but also gone incredibly quickly. And I know that's a lot of people's experience of what's happened during the pandemic has made time warp in all sorts of ways. We have, across the whole of the union movement, found that the COVID-19 has really thrown so many workers' lives into crisis, and particularly for, particularly for women workers, the impact, as you said, has been dramatic. We've seen a really, the notion that we're all in it together, you know, is I think trite when you actually look at the very disproportionate impact that this virus has had across different groups of people. And of course, what we know is that because of where women work, that it's the industries that are predominantly in that have been hardest hit in terms of loss of jobs and hours. So when you talk of retail, hospitality, they have been very, very hard hit, but also women that work in higher education, in that sector, and of course in many other areas as well. But we know that if your job was already insecure, and this was a fault line that disproportionately affects women, if your job was already insecure pre the pandemic, then what the pandemic showed is that you were the first to be let go, those thousands of workers who lost jobs overnight. But when you look at the figures of what happened in April, 600,000 people lost work in April, and 55% of all the jobs lost were held by women. But then if you look at what happened of hours of work, it's even more dramatic. So women's hours were reduced by 11.5% compared to 7.5% of men. So that's a very clear indication that capacity to take work away from women is far greater as well. What we know has been happening is that women have also been in many of the jobs that we've relied on. Of course, you think of nurses and workers in the health system, not just nurses, those involved in keeping our hospitals clean and in feeding people, and all of the ancillary work that goes around the direct provision of health care. That's predominantly done by women as well. It's also the case that if you think of retail workers, there's been some workers have had a lot more work if you think about what's happened with supermarkets, but then of course others have been really hard hit with just the closure of many shops and no work available at all, which was why we spent a lot of time at the beginning of the pandemic campaigning hard for a wage subsidy. And one of the problems with what was introduced with JobKeeper, important to have a wage subsidy put in place, but the missing out, the exclusion from that scheme of women who, of workers who hadn't worked for the same employer, casual workers, for more than 12 months, has had a dramatic impact. That, combined with visa workers who have been left not only with no access to JobKeeper but no access to JobSeeker, has literally had those workers with not enough food to eat. So the impact of COVID-19 on particular groups of workers has exacerbated some of the issues that we see in your report, because of course people are more vulnerable. They're more vulnerable, they're more reliant on the need to work or to get hours. So their capacity to be able to report or stand up against violence or harassment is put at risk, because they're even more fearful about job losses and the consequence of it, and the isolation of what's happening. We also know that there's been increased violence here in Australia at home and at work that has impacted on women dramatically. So the incidences of family and domestic violence in the home situation, as well as violence at work, is being reported across all of our industries and sectors through the pandemic. The other thing is that the pressure, of course, of juggling, and so many again we see that uneven impact where primarily the work of helping your children be able to, when they weren't able to go to school, but be able to navigate what they needed to do in terms of education and schooling, was something that really majority of that work fell on women, as well as many other of the caring responsibilities for people that needed extra support and care. So it hasn't been an even pandemic. It's been a very uneven pandemic. And for me personally, I feel like that I've been very proud of our union movement, the fact that people have worked so hard to make sure that we both fought hard to ensure there were extra protections and rights for workers in the midst of this, that we were at the forefront of what's been needed in terms of keeping people safe at work and knowing what was and wasn't acceptable in terms of safety, but also being able to argue for and win things like access to paid pandemic leave, a fight that we're still having to make sure every worker has access to it, and the campaigns around extending JobKeeper, and JobSeeker too. So the work of the union movement has increased during the pandemic, and I know so many union organisers and delegates and officials who talk to me about how what they've done is really been involved much more personally with many of their members who've needed advocacy and support, and being part of a strong movement at this time more than ever.
Yeah. And in particular, I agree. There's a lot of people who've been particularly amazing during this period, and it is pleasing to see, government engaging really actively with unions, and so that's welcomed, I think, and I think we'll all have a better outcome with that, and employers. So I'll go to some of the questions before I. Our time runs out for us. So I will have a go at answering a couple of them, because I think they're ones for me, and then there's one that I'll come to you from Michele. So from Rebecca, there was a question about, is it the case that on the prevention end, we will see the Australian Human Rights Commission Act as a regulator with power to go in and inspect and make sure that employers have a prevention strategy? So the recommendation, absolutely, as Michele flagged, is the positive duty, which, arguably exists in a form anyway under the safety legislation. But the positive duty, we know from Victoria and we know from other countries, that positive duty expecting employer to take action is very important. But as for any legal requirement, the enforcement, the monitoring, the active ability to identify and hold accountable is a really important part of employers and any duty holder taking seriously their obligations. So we have recommended that the Human Rights Commission, as Michele raised, it would require funding but be given some enforcement powers. In practice, we don't, it just simply wouldn't be that we would be resourced to go out and investigate no matter what, every employer, but the ability to both support, educate and help employers act in, and then take action to ensure there is some compliance is an anticipated part of our recommendations. That one without the other will be not as effective as it could be, and that has been the experience in Victoria. The next question, which I can take, the first three I think I can take, has there been a response from the federal government about the establishment of the council? I think that you've heard from what we've said that there actually, and we understand why, there hasn't been a response at all to the report. But having said that, I know from the reference group, which included WorkSafe Australia, and also from our consultations with the Fair Work Ombudsman and Fair Work Commission, that there is the spirit of us all wanting to work together irrespective. And so I expect that informally we are already, well, I certainly know we've already done a webinar with Bernadette O'Neill from the Fair Work Commission that I'd encourage you to look at if you're interested in, to give a sense of how we're already anticipating that we could work together to just make sure that we are better coordinated, more consistent, and we're getting the best practice from each other. So no response, but definitely initial start of action around what we can, even without the government response. And then the last question that I can go to is the expectation of government response. Are we talking federal or state? And that's a great question, because actually, as we did these recommendations, and there's 55 of them, some of them most definitely are federal government, some of them without doubt are state government, and others are employers or other organisations like the Australian Institute of Company Directors doing some training, so there is a range of different audiences for our recommendations. But as a part of the Human Rights Commission, we were supported by the Attorney General's Department and the Minister for Women to do the work, and it is the federal government that I look to for the initial response. Now, if I go to a question from Sasha for you, Michele, how do you think the Stop Sexual Harassment Order should work, learning lessons from the Stop Bullying Order and its limitations? E.g., the requirements for conduct to be repeated pose a risk to health and safety. There is a risk the behaviour will continue. No provision for awarding compensation damages and applies only to workers in constitutionally covered businesses, i.e. no coverage for some workers, for example, public sector workers. And I'll say in handing that question to you that we, in proposing the new Stop Sexual Harassment, absolutely would be suggesting it's the best version of the Stop Bullying Order, and acknowledge that there have been feedback about what hasn't worked in that system. So Michele, have you got any reflections on that mechanism, or other, I'm interested in as well for unions, other mechanisms to deal with complaints? It just doesn't always have to involve ending up in a court.
Yeah, thanks, Kate, and thanks, Sasha, for the question. We all know that the Stop Bullying orders have been not very effective. So we do want to see a different approach taken in the capacity to have orders around stopping sexual harassment at work. And this is something that will make a very big practical difference to workers if we can get it right. So a couple of the key points that Sasha raises in the question, I don't think there should be a requirement that it's been repeated behaviour. What we know about harassment is that if someone's been harassed once, then that person is likely to harass them again. So why should we put a worker through the process of having to be repeatedly harassed before they have a right to have an order stopping that behaviour? So I think that combination of needing to be repeated, or the terminology around that the conduct is going to continue, having to prove that, I think that would be problematic if we repeated those mistakes in the sexual harassment order. The other thing I'd say is that it should cover every worker. This shouldn't be limited to constitutional corporations. These are artificial legal distinctions. What we want is every worker to be safe, and every worker to know they've got the capacity to go off to the Fair Work Commission and have an order put in place, and that would happen rapidly. So having clear procedures within the Fair Work Commission that meant that it was easily understood and easily done, with the least degree of stress, I suppose, on the person making the complaint. The other thing is that I think that we know that for that to work, we've previously had a view that it would be good to have some specialist expertise within the Fair Work Commission. So to have a panel or a body of people within the Fair Work Commission that understood areas of discrimination and inequality and harassment better, whose expertise could be developed and trained, and they could be trained up so that you really had an expert group of people, commissioners within the Fair Work Commission that these matters could go to. We all know the reality of what happens to people who make complaints of harassment, and the level of understanding and expertise of the person who's making a decision about whether somebody should get an order to stop harassment, we would want to be very high. We don't want the wrong people who don't understand the complexities of these issues and the very real danger people face hearing those orders. So there's some of the things that I'd mention in response, Sasha.
Fantastic. Okay, a couple more and I'll give you a warning because I'll come back to you, Michele, to just talk a bit about industry initiatives. I know obviously unions are some of the best placed people, so I'll come back to just talk about what sort of industry initiatives you've seen the union movement kind of get behind on harassment or other things. So I'll answer a couple more questions that I think are in my patch. One of them is, are any of these requirements within the scope of the workplace gender equality reporting and compliance? So in the work, I was very influenced in the reporting, looking at current knowledge about what is effective in terms of changing workplace practices and systemic issues. And one of the things that we know more about now is behavioural economics and how people respond. And we have seen, particularly under Libby Lyons, there's been really an increased focus of at least larger or employers of over 100 on their reporting of gender equality stats. And in looking at that, we have made a recommendation that the Workplace Gender Equality Agency, there should be reporting on particular sexual harassment measures. But in that section, we do talk with caution about reporting simply numbers of complaints. So unions know better than any that people, for a range of reasons, choose not to make formal complaints. And I think if you ask the reporting and as evidence of the level of sexual harassment is complaints, then you end up with a position where employers are incentivised to stop complaints more than they are incentivised to stop sexual harassment. So our recommendations about that is to really say we know the value, particularly on gender equality, that reporting to the Workplace Gender Equality Agency, how much that has helped employers improve their practice, and that this should be something that it's in a mix. So we think there should be regulation, there should be laws, there should be incentives, there should be transparency. It's a mixture of all those things. And then there's another couple of questions. It's probably a longer time than I'll have because I do want to pass the last, but there is discussion about codes of practice. So the recommendation specifically on the work health and safety regs is a guideline is prepared first, but with the code of practice as the end result, and that really to give better clarity. And similarly, that something similar be provided to support the positive duties. So there's a question from Sarah as well about that there is no doubt that employers are really keen to know, well, what is meeting the positive duty? How does that work? What are the standards? One of the things that I've reflected is that, of course, every time I talk to employers, they just want a checklist. They want to tick it off. You know, have we got the policy tick? And the reality is creating a safe and respectful workplace is not as simple as someone in HR drafting a policy. And so it's the combination of things which workers know. You know, when I talk to workers in big or small businesses, so I did really ask them, now, what was a hallmark of a good workplace? Because I heard a lot of stories of not good workplaces, and some of you will hear that a lot as well. And they would generally say, where I know I I'm respected, where I get treated with respect, but also I feel safe to speak up if something happens. And that was time and time again, and it had no connection to policies. And people would say, I know there's a policy that says this, but that's not what my day-to-day experience is like. So they asked some great questions. But Michele, can I go to you? Because one of the last recommendations in the workplace chapter was, I am absolutely convinced that the way we really will get change is by better industry action. And you have in your comments described this idea that there's systemic issues, that when things happen, actually they happen all over the same industry. When we did the work with the SDA on their survey, it was really identifying that if you're a retail or a hospitality worker, you have a high rate of harassment by customers and clients, and so you can focus on that. So our recommendation there is industry initiatives, but by that I mean employers, unions, workers, actually everyone gets together, not that the employer industry association decides what will happen. But I do think getting together as workers move around one industry will make their life much more easy. I know the union has done some really amazing, campaigns, and organising is the sort of core business, but can you think of some examples that you've seen that have worked well or that might work well?
Thanks, Kate. And one of the problems, of course, with us doing this in this way is that I'm sure there's a whole lot of union people on the line who are going, I could tell you about what I'm in the middle of doing. And so my apologies that we don't have the facility to sort of let that happen today, but I will mention a couple that I know about. I'll start with the SDA, in fact, because that work that is about how do you create a safe work environment from sexual harassment, but also other forms of harassment. And as we saw during the beginning of this pandemic, in fact, assaults that happen to workers in the retail sector has long been an issue that the SDA have campaigned around. So there, no one deserves a serve campaign. I think now, initially that was sort of developed up by the union, but there was some reluctance from some of the key employers for that to be rolled out in workplaces, but that's changed. And so that cooperation and that work between the union and employers about making sure that that message would get through to consumers and other co-workers about respect in the workplace and what was acceptable behaviour in terms of people that are serving you has been a really important initiative. The other one that I'd mention, it would be the work in the Media and Entertainment and Arts Alliance has worked with employers in the live performance and in the screen industry. So again, you're right, these were systemic problems within those sectors of ongoing harassment and expectations that somehow, because it was part of a performance, that the rules were different, that, that behaviour was seen to be acceptable, that in other workplaces or other work environments wouldn't be, which of course is not the case. So there was great work done in developing up those codes, which were joint initiatives between the MEAA and the employers in those sectors. So there are a couple that I'd mentioned, but as I said to you, what I know is that this is work that happens workplace by workplace as well as sector and industry by industry between unions and employers. So my own experience as an organiser tells me that some of the most effective and powerful work that happens about changing behaviour is when unions and employers are able to identify what do we need, and unfortunately it's often triggered by complaints, and then what do we do to try and stop this happening in the future, but very powerful change that's been about making sure people understand their rights and obligations, putting in place procedures, training, clear requirements about what is and isn't acceptable behaviour, making sure that people know that they do have a right to be represented, that they can have their union take this issue up for them, that they're not alone, and then having employers with agreements in place about who will be responsible for dealing with complaints and how they'll be done. Some of the most powerful work we do is that joint union employer approach, workplace by workplace, as well as these really important industry and sector initiatives.
Fantastic. Now I'm looking at the time, and so I might wrap us up, but I'll say one additional, because I was really attracted by some of those initiatives, the industry. So that media collaboration, which I'm the biggest fan of. At the time that happened, obviously the Harvey Weinstein story hit globally, but it did hit in Australia, and there was a lot of sitting up and taking notice here. And it's not only that it's part of, you know, the idea that it's part of the business, but I've used the media industry as an example that you would know in lots of places to say, well, let's combine it. There's still mostly men at the top. It is a very insecure type of work. You do your 6-month season and then you're off, and you know you kind of move around a bit. You've got high competition, and you've got a sexualized kind of workplace. So you combine, so this is a good example of the systemic issue. But when it happened, that I was involved with, they consulted with me to their credit about doing their new code of conduct. And they were so proud, and I spoke at several conferences and I met in roundtables. And I remember as a 20-year employment lawyer thinking, everyone's got a policy. You know, they were coming up with a new policy, and I just was thinking it's not for lack of policy that this is happening. But I have completely changed my view, not for the policy, but by doing one policy across the whole industry. I have heard repeatedly that now there's no confusion. If you start on a new season of a new show, everyone gets brought in, the director sits down, and they just get reminded of the same policy. It's not sort of, are you casual? Did you get the briefing? You know, what's the deal here? Do I speak to someone? So it's been that idea of recognising as an industry as a whole, we all agree with this one position. And so I was really impressed by that. The other place, as well as I've seen some good initiatives, or I heard about them in the consultation. So people did come, as you're describing, to tell us in the liquor, sort of the liquor union, and they were working really well with this idea of what you can do in a bar, because no one wants the bartenders being harassed. And similarly, the student unions at the universities, just the, you know, it does take a bit of work for everyone to accept that working together is the best thing when you've come from a history of, you know, one side against the other. But it's like watching the light go on when it all suddenly realises that together we can do a lot better. So I love those examples, but I also do think they are the solution for the future. And I think that I'm certainly going to push as hard as I can for more of that kind of action. So I will close today and start, Michele, by thanking you. I absolutely know how busy you are right now. So the fact that you found this time for us is incredibly appreciated from my point of view, and the fact that we can save this in a webinar that we can share to others is a really fantastic thing. I hope those of you who've joined, thank you so much for joining, that you can share and promote the other webinars, but also this one. We'll make sure you've got access to it. I hope you think it's so great you want everyone you know to listen and watch it, and also check out our website for upcoming webinars and encourage others to attend. So the last thing I wanted to say was, as we close this, when you look at our report and the size of our report, it really does show the breadth and the depth of the complexity of the issue. But really at the core of what we're talking about in terms of sexual harassment, it's actually really simple. And the reality is that sexual harassment is absolutely not inevitable. It is unacceptable and it is preventable. And we hope we've delivered a report that gives solutions, but actually it will only change if people who are joining here and across the country engage and just start getting involved to prevent sexual harassment and create better, safer workplaces. So thank you very much for taking time. I really appreciate that. I really appreciate your time, Michele. Thank you.
Thanks, Kate.